Welcome once again to Know Your Rights University in association with Natural Lessons Compact LLC. We're back at you once again with another video. We hope that will be educational, informational, and beneficial to you. Let us begin by sharing our screen. All right. Public Trust Doctrine and Incidents Thereof is the title of this video. What does the word trust mean? Excellent and necessary question, especially in the context of law, governance, and theology. The word trust has a layered meaning depending on whether we're speaking in moral, legal, or constitutional terms. Let's examine it in each of those dimensions, beginning with its root and then moving to its highest constitutional implications. Etymological and moral meaning. The word trust comes from the Old Norse trost, meaning confidence, protection, or reliance. In its oldest and most universal sense, trust is faith placed in the integrity, fidelity, and benevolence of another. To trust is not merely to believe, it is to commit something of value, one's welfare, property, or life, into the care of another, with moral expectation that the other will act faithfully. In theology, this is the essence of the divine human relationship. Trust in the Lord with all thine heart, and lean not unto thy own understanding. Proverbs 3 and 5. Here, trust means placing confidence in divine order, not blind reliance, but conscious faith that the moral law governing the universe will be upheld. Thus, in the moral dimension, trust equals faith and duty. It is always two-sided. One entrusts, and the other must be faithful. Legal meaning, a fiduciary relationship. In law, trust is a technical term of great importance. It signifies a fiduciary relationship, that is, a relationship founded upon confidence and good conscience between parties where one holds property, power, or responsibility for the benefit of another. Classical definition, equity jurisprudence. A trust is an equitable obligation binding a person, the trustee, to deal with property over which he has control, the trust res, for the benefit of another, the beneficiary. Essential elements of a legal trust. Number one, trustee is the one who holds legal title or authority. Two, beneficiary is the one for whose benefit the property or power is held. Three, trust res, or subject matter, is the thing or duty entrusted. Four, fiduciary obligation is the trustee's highest duty of loyalty and care to the beneficiary. The trustee must act not for his own gain, but for the benefit of the beneficiary. He cannot mismanage, misappropriate, or place his own interest above that of those he serves. Constitutional meaning, the public trust doctrine. In constitutional law, particularly in American and indigenous legal traditions, trust takes on a sovereign dimension. The founders and later jurists used the word to describe the moral and legal duty of governments to act as trustees for the people. The people as beneficiaries. All legitimate political power is held in trust for the people, never as a private possession of rulers. This principle arises directly from the Declaration of Independence and the Lockean idea of government by consent. That is, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. This means that public officials, from the president to local magistrates, are trustees of the public good. They hold their offices, property, and discretion, not absolutely, but conditionally, under a fiduciary duty to secure life, liberty, and property for the beneficiaries, the people. 2. The federal Indian trust responsibility. The term trust also has a specific legal application in U.S. law with respect to Native nations, as reaffirmed in Order Number 3335 by the Department of the Interior. The federal trust responsibility is the binding legal and moral obligation of the United States to protect tribal lands, assets, resources, and treaty rights, again, as a trustee for sovereign Native peoples. This means the federal government does not own those resources, it holds them in trust, bound by the highest moral obligations to administer them faithfully. Philosophical and theological integration. When seen at the highest level, trust is the moral architecture of all legitimate order between God and man, covenant, faith, and obedience, between ruler and people, constitutional trust, authority, and accountability, between individuals, fiduciary duty, honor, and responsibility. Therefore, trust is not mere belief, it is stewardship. It binds the trustee to act as a faithful agent of the will or purpose that entrusted him with power. Summary definition, domain, definition of trust, and key relationship. Moral/theological. The definition of trust under this domain is confidence placed in the faithfulness of another, especially in divine order. Key relationship, faith and fidelity. Under the legal domain or private law, a fiduciary relationship in which one holds property for another's benefit. Key relationship is trustee to beneficiary. Under the domain of constitutional/public law, the duty of government and its agents to exercise power only for the people's welfare as trustees of the common good. Sovereign people in relation to public office holders. Under the domain of spiritual integration, the eternal law by which higher intelligence delegates power to those who can responsibly express it. God to humanity. In essence, trust is the sacred confidence that creates duty. It is the bond that unites the moral, legal, and constitutional order, the bridge between divine intention and human responsibility. Let's trace how the concept of trust became embedded in American constitutional law and political philosophy, forming what jurists call the public trust doctrine and, in the native context, the federal trust responsibility. Origins. The ancient and English foundations of public trust. The idea that power is held in trust for others is older than the United States itself. It comes from ancient and natural law principles refined through English common law and colonial experience. 1. The ancient foundation. In classical philosophy, all authority was considered derivative of divine law. Rulers were stewards of the people, never owners of them. Aristotle, Cicero, and later the Christian scholastics all held that public office is a moral trust. Power exists only for the welfare of those governed. 2. English common law, the king's trust. Under English common law, the crown was said to hold certain things such as navigable waters, fisheries, and forests in trust for the public. This meant the king could not alienate them for private gain. He was merely a trustee of the realm. This is the embryo of the American public trust doctrine. When the American Revolution severed the political link to the crown, sovereignty and the associated trust devolved to the people. The people became the new Sesticate Trust, or beneficiary of all public property, powers, and laws. 2. The Declaration of Independence, Trust, and Consent. The Declaration in 1776 expresses this doctrine in natural rights form, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. This sentence encodes the trust relationship between the people and their government. The people, settler and beneficiary, create the trust by instituting government. The government, trustee, holds and exercises power solely for the purpose of securing rights. The trust, the rights, trust res, the subject of the trust, life, liberty, and property. When a government becomes destructive of these ends, it has breached its trust. The people, as the settlers and beneficiaries, have the right to revoke or alter it, to alter or abolish it, and institute new government. Thus, government is not sovereignty itself, it is the trustee of sovereignty. 3. Constitutional embedding. We the people, as sovereign grantor, the Constitution of 1787 operationalized the same principle. Its opening phrase, we the people, is a trust instrument in miniature. We the people do ordain and establish this Constitution. Here, the people declare themselves the source of authority, the settler and sovereign, delegate limited powers and trusts to Congress, the executive, and the judiciary, retain all undelegated powers. 10th Amendment. Every federal officer swears an oath not to the government itself, but to support this Constitution, the trust document. Breaking that oath constitutes a breach of fiduciary duty against the beneficiaries, the American people. Alexander Hamilton described it explicitly in Federalist Number 84. The people surrender nothing, and as they retain everything, they have no need of particular reservations. This language perfectly reflects a trust structure. The trustee holds delegated power under conditions of express limitation, revocable by the grantor. Judicial recognition. The public trust doctrine. The public trust doctrine is the continuing legal expression of this constitutional philosophy. Early articulation in Illinois Central Railroad Company versus Illinois, the Supreme Court held that the state holds title to the lands under navigable waters in trust for the people. The state can no more abdicate its trust than it can abdicate its police powers. The court reaffirmed that government cannot alienate or privatize essential public resources. They are held in trust for all. Modern doctrine. This doctrine has since expanded to include environmental stewardship, air, water, forests, public lands and resources, the integrity of public institutions, fiduciary duty of government officials to act in the public interest. Thus, the public trust is a living embodiment of we the people as the ultimate owner of all public authority and property. The federal trust responsibility toward native nations. Distinct but related to the general public trust doctrine is the federal trust responsibility owed to indigenous nations. Historical foundation, beginning with Cherokee Nation versus Georgia. Chief Justice John Marshall described tribes as domestic dependent nations. Their relation to the United States resembles that of a ward to his guardian. While that paternalistic phrase reflects its error, it established the legal duty of the federal government to act as trustee for tribal property and sovereignty. 2. Executive codification. This was later reaffirmed in Secretary's Order Number 3335 in 2014. Reaffirmation of the federal trust responsibility to federally recognize Indian tribes and individual Indian beneficiaries. The trust responsibility consists of the highest moral obligation that the United States must meet. This trust relationship is unique. The federal government holds lands, assets, and treaty obligations not as owner, but as fiduciary, bound to act with the highest degree of good faith and candor. 3. Self-governance as the fulfillment of trust. Modern federal policy, as Joseph Calt of Harvard observed, has shown that tribal self-determination through self-governance is the only policy that has worked. In other words, the federal trust's fulfillment is achieved not by control, but by empowerment. allowing sovereign native nations to exercise their own governmental powers. The people's trust in modern public law across all contexts. The central idea is consistent. All power, political, economic, or fiduciary, is held in trust for the benefit of others, never as private dominion. This idea defines the constitutional ethics of republican government. It transforms office into obligation and ownership into stewardship. The trustees' duties of government. Number one, duty of loyalty. Act solely for the public good, not for private interests. Number two, duty of care. Manage public resources prudently and lawfully. Number three, duty of accountability. Remain answerable to the beneficiaries, the people. Four, duty of preservation. Maintain the integrity of the res, the constitutional order itself. When these duties are violated, whether through corruption, secrecy, or abuse of power, the trust is broken and sovereignty reverts to the people for redress and reform. Synthesis and constitutional meaning. Aspect, trust doctrine, sovereign relationship. The moral basis. Power implies duty. Authority exists for the benefit of others. Rulers are servants of the people. Legal basis. Trustee holds property or power for a beneficiary and cannot use it for self. Government holds power for the people. Constitutional basis. We, the people, created government as trustee to secure rights. Sovereignty equals the people. Government equals their agent. Indigenous law. The U.S. holds fiduciary duty to protect tribal property and autonomy. Federal-tribal trust relationship. Public policy. State cannot abdicate or alienate public trust resources. The public is perpetual beneficiary. In sum, trust is not an accessory to government. It is the form of government under a constitutional republic. The Constitution itself is the trust instrument. The people are the beneficiaries, and every office holder is a trustee bound by oath to the faithful administration of the trust. When that duty is honored, liberty flourishes. When it is betrayed, sovereignty reverts to the people. For the trust can never die as long as the people live. How does this statement relate to the public trust doctrine? Demanding entry evidence. Make them prove how you entered the alleged capacity. Hanson's quiet rule. Jurisdiction cannot arise from unilateral reclassification by the state. Example 3. Licensing/regulatory case written demand. Produce the instrument by which respondent entered the regulated capacity alleged, including application, acceptance, consideration, and statutory authority governing entry. What usually happens, agency produces a statute, insufficient. An assumption by engaging in activity, insufficient. They cannot produce a voluntary entry instrument. Result, jurisdiction collapses at the threshold. No need to argue merits. Expansion of the statement. Licensing/regulatory case. Threshold, jurisdictional defeat. The written demand you quoted is a jurisdictional instrument that forces an agency to produce record evidence establishing that the respondent ever entered the specific regulated capacity the agency presumes. The demand is produce the instrument by which respondent entered the regulated capacity alleged, including application, acceptance, consideration, and statutory authority governing entry. This is not argument. This is a fact-finding demand rooted in fundamental jurisdictional law. Below is the legal expansion. Fact. No agency can impose regulatory jurisdiction without proof of voluntary entry. Every regulatory capacity under federal and state law is created by statute, but the regulated status itself is never automatic. To assert jurisdiction, the agency must demonstrate a voluntary application into the regulated classification, a formal acceptance by the regulatory authority, consideration because all binding legal relationships require consideration, a specific statutory provision that authorizes the agency to create and confer the regulated status in the first place. These are not optional, they are mandatory jurisdictional prerequisites derived from Supreme Court controlling authorities, Hansen versus Dankler. Jurisdiction cannot arise from unilateral agency assumptions. Federal Trade Commission versus American Tobacco Company. Agencies possess only the powers expressly delegated by Congress. United States versus Morton Salt Company. Agency demands must be tied to lawful jurisdiction, not presumption. Acts of Congress foundation, congressional delegation in regulatory statutes. Statutes at large require a defined scope of regulatory authority, defined mechanism for entering the regulated capacity. Without compliance, no jurisdiction exists. Conclusion of law until the agency demonstrates the voluntary creation of the regulated status. No jurisdiction can attach and no enforcement action can lawfully proceed. That demand, the one asking an agency to produce the instrument by which respondent entered the regulated capacity alleged, rests on the same underlying legal architecture as the public trust doctrine. Both doctrines revolve around proof of delegated authority and the principle that sovereign power is fiduciary, limited, and must be exercised only under lawful entrustment. Capacity equal a lawful power to act. In federal law, capacity refers to the legal ability, authority, or competency of a person, entity, or institution to perform a particular act under the governing legal framework. Capacity is not willingness, interest, moral authority, or practical power. Capacity is a legal status defined strictly by law, not by presumption. Let's unpack how these connect step by step. The core premise of the public trust doctrine. Under the public trust doctrine, all sovereign power, property, and jurisdiction are held in trust by government for the people, the original and perpetual beneficiaries. The government is the trustee, the people are the beneficiaries. The Constitution and statutes at large are the trust instrument. No government entity possesses inherent power. Each department, agency, or office must trace its authority to a lawful grant from the people through constitutional or statutory delegation. The state holds title to the lands under navigable waters and trust for the people. The state can no more abdicate its trust than it can abdicate its police powers. Illinois Central Railroad versus Illinois. This means every exercise of public power must be demonstrably authorized and used for the beneficiary's interest only. When an official or agency acts without lawful entrustment, it breaches the public trust. The demand for entry evidence as a fiduciary challenge. The written demand in your example is a trust verification instrument. It in the scope of the trust relationship before exercising power over another's rights or property. The demand produce the instrument by which respondent entered the regulated capacity forces the agencies to produce the evidence of entrustment. Element, trust law equivalent, and regulatory context. 1. Application. Is voluntary consent by the beneficiary or entrant. The regulatory context is did the person apply for a license or status. 2. Acceptance. Trust law equivalent, trustee's acknowledgement of the relationship. Regulatory context, did the agency formally accept the application? 3. Consideration. Trust law equivalent, the mutual exchange forming the fiduciary bond. Regulatory context, was there a statutory or contractual benefit or exchange? 4. Statutory authority. Trust law equivalent, the trust instrument, delegation of power. Regulatory context, where does the law authorize this regulatory capacity? Unless these elements are established, the agency has no proof of trust formation. That is, no legal relationship giving it jurisdiction. Hansen's quiet rule and the limits of fiduciary jurisdiction. Your reference to Hansen versus Dankler is precise. In that case, the Supreme Court held the unilateral activity of those who claim some relationship with a non-resident cannot satisfy the requirement of contact with the foreign state. Translated into fiduciary and public trust terms, jurisdiction cannot arise from unilateral presumption by the state. There must be a voluntary, knowing act that brings a person into the regulated or fiduciary sphere. So, If an agency merely assumes someone is subject to regulation because of residence, occupation, or engaging in activity without showing the instrument or entry, it has no lawful trust relationship with that person. This is identical to the fiduciary rule. A trustee cannot claim dominion over a beneficiary's estate without proving the deed, will, or trust instrument that created that relationship. The public trust doctrine and application. The public trust doctrine requires that all public authority must trace to a lawful delegation. All exercise of that authority must be in the interest of the beneficiaries. No presumption of jurisdiction can override proof of entrustment. Demand for entry evidence operates on that exact principle. It says, show the documentary trust by which I, the people or individual, to enter the regulated capacity or regulatory capacity you allege, and show the statutory provision that empowers you to create that capacity. This converts the proceeding from an argument about compliance, the merits, to an inquiry into the legitimacy of jurisdiction, the trust itself. When no instrument exists, trust failure and jurisdictional collapse. If the agency cannot produce a signed application, voluntary act, and acceptance, mutual assent, statutory delegation, authority of trustee, and consideration, legal value exchange, then the trust relationship was never formed. No fiduciary nexus exists, and therefore no jurisdiction attaches. This is identical to what happens in trust or probate law when a trustee acts without a valid deed of trust. All actions are void ab initio, not merely voidable. In the public sphere, this means the state cannot exercise regulatory dominion absent proof of lawful entrustment. To do so would convert a fiduciary office into a feudal ownership, an act forbidden by the constitutional public trust. Connecting the dots, private entry versus public fiduciary authority, concept, legal source, and principle. Public trust doctrine, Illinois Central, U.S. constitutional law. The government's powers are held in trust for the people. They cannot exceed delegated authority. Hansen rule, legal source, Hansen versus Dankler. Principle, jurisdiction cannot arise from unilateral state action. There must be a voluntary connection or consent. Demand for entry evidence, legal source, fiduciary challenge procedure. The principle behind it requires proof of voluntary and lawful entrustment before regulation or jurisdiction attaches. Result, constitutional limitation on power, no jurisdiction without evidence of lawful trust formation. Constitutional integration under the 5th and 10th Amendments, the people retain all rights not delegated. Delegation of authority is the act of entrustment. Without documentary proof of delegation or consent, the agency stands outside the trust. It becomes an interloper rather than a trustee. Therefore, the demand for entry evidence is an invocation of the public trust doctrine at the individual level. It enforces the constitutional requirement that all exercises of public authority must be traceable to lawful delegation and voluntary entrustment, not presumption or coercion. In summary, the public trust doctrine declares that all sovereign power is held in trust for the people and must be proven, not presumed. The demand for entry evidence applies that same principle to regulatory or licensing context, compelling the government to produce the trust instrument establishing jurisdiction. Hansen's rule confirms that jurisdiction cannot arise unilaterally. There must be voluntary entry or consent. When no entrustment can be proven, jurisdiction collapses and the trustee or agency has no lawful authority to act. So, say for instance, if someone applied for a liquor license from the state of Illinois and the license was granted after that person paid the license fee, would this be considered as that person entering into the capacity of a licensee to be regulated by the state? Yes, that's a good concrete way to see what the law means when it talks about voluntary entry into a regulated capacity. Here's how it works under ordinary U.S. administrative and contract law using your Illinois example. Voluntary application creates the relationship. When someone fills out and submits an application for a liquor license, they are asking the state for permission to engage in an activity that the legislator has decided to regulate. That act of applying is a voluntary invocation of a regulatory scheme that already exists under statute in Illinois under the Liquor Control Act. In other words, the applicant is saying, I wish to operate in this area, and I accept the conditions that the law attaches to that privilege. Issuance and payment complete the exchange. When the Illinois Liquor Control Commission accepts the application, approves it, and issues a license upon payment of the prescribed fee, two things happen. One, statutory acceptance. The agency formally brings the applicant into the class of licensees recognized by statute. Two, consideration. The applicant pays the fee and agrees to abide by the regulatory conditions. The state, in turn, grants the legal privilege to sell alcohol. That set of actions is what creates the regulated capacity. From that point forward, the person is a licensee and is subject to the Commission's jurisdiction for matters that the Act covers: renewals, inspections, penalties, and revocation procedures. 3. Why this matters for jurisdiction. If the agency later takes enforcement action, say, for serving alcohol after hours, it can establish jurisdiction simply by producing the license and the statutory authority for regulation. Those documents are the evidence of voluntary entry and lawful delegation that a court would require. If, by contrast, the agency tried to regulate someone who never applied and never received a license, it would need another statutory basis for jurisdiction. It could not rely on the licensee relationship because that relationship was never formed. How this fits the fiduciary or public trust frame. Public trust side. The state's power to regulate alcohol exists only because the people, through legislation, delegated that authority for public safety and welfare. The agency must act within that delegation. It cannot regulate outside the statutory class or impose conditions not authorized by law. Private side, licensee. By applying and accepting the license, the individual enters the trust relationship voluntarily and agrees to the duties and liabilities that the legislator attached to that privilege. Thus, yes, the act of applying, being accepted, and paying the fee is exactly what creates the status of licensee and subjects the person to regulation. It is the lawful instrument of entry that would satisfy the kind of evidentiary demand you describe. How the public trust doctrine still applies. Here's where the doctrines connect. The state holds police power and trust for the public. That means the legislature and its regulatory agencies can set reasonable conditions on activities that affect public welfare, like liquor sales. A licensee voluntarily enters that trust framework by applying for and accepting the license. The individual acknowledges, I will comply with the conditions imposed for the protection of the public interest. But this does not make the licensee a trustee or employee, only a participant under the trust regulatory reach. What about if the person never entered into the regulatory relationship by applying for a license, but yet he engages in the regulated capacity without a license? How might the law treat such a person? That's an important practical question, and it is one that every regulatory system has had to answer since the earliest days of licensing law. Here is how the law actually treats that situation step by step. The basic premise. When the legislator enacts a licensing statute, say the Illinois Liquor Control Act, it uses the state's police power to make certain activities conditional on prior authorization. The statute says, in effect, no person shall engage in the business of selling alcoholic liquor without first obtaining a license. That provision does two things. It creates the regulated class, licensees, and it defines an unlawful act for those who engage without the license. 2. Engaging without applying. If someone never applied for a license but still performs the activity, that person has not entered the consensual or fiduciary relationship that binds licensees. However, by operating in violation of a valid law, the person triggers the state's enforcement power. The state is not claiming to be in a contractual or fiduciary relationship with that person. It is invoking its police power to prevent or punish unlawful conduct. So the person is not treated as a licensee or as a public employee. They are treated as a violator of a statutory prohibition. How courts see it. Courts routinely hold that the requirement to obtain a license is a lawful condition imposed for public welfare. Performing a regulated act without the license is an offense, sometimes civil, sometimes criminal, depending on the statute. Example, Illinois, it shall be unlawful to sell or offer for sale at retail any alcoholic liquor without having first obtained a retail liquor dealer's license. Penalties under Section 10-1 of the same Act include fines, closure, or prosecution. There is no need for the state to provide voluntary entry into a regulated capacity because the violation itself is defined by the statute. Why the state still needs jurisdiction. Even then, the agency or court must still show the statute was validly enacted within the police power, the alleged conduct actually occurred in its territory, and the accused fits the statutory description of the prohibited act. That is the jurisdictional foundation, not consent, but territorial and subject matter authority. If those are missing, the enforcement action fails. If they are present, the person's lack of a license becomes the basis for liability, not immunity. Relationship to the public trust doctrine. The public trust doctrine continues to frame this in moral constitutional terms. The state as trustee must regulate in the public interest, not arbitrarily. The law, as the trust instrument, must clearly define the conditions of lawful activity. The individual, by acting without authorization, is not a trustee or an employee, but is in breach of a lawful public condition, and the trustee, the state, has the duty to enforce that condition for the beneficiaries, the public. In short, if a person applies and is licensed, they enter a regulated trust relationship. If a person acts without applying, they remain outside that relationship but become subject to enforcement because they infringed on a domain that the state holds in trust for public welfare. The result: situation, legal status, how the state proceeds. Licensed operator, voluntarily entered regulated capacity subject to administrative jurisdiction. How the state proceeds. Enforcement through licensing agency, revocation, suspension, fines. Unlicensed operator, legal status, no consensual relationship, acts in violation of statutory provision. How the state proceeds. Enforcement through police power, civil or criminal prosecution. Constitutional limits. Even then, enforcement must be grounded in a valid statute, not arbitrary regulation. Provide due process, notice and opportunity to be heard. Avoid excessive penalties that would violate substantive due process or equal protection. Those conditional safeguards ensure that the trustee, the state, stays within the fiduciary boundaries when protecting the public trust. Summary: a licensee voluntarily enters a regulated capacity and is bound by its conditions. A non-licensee who engages in that capacity does not become a public employee or a licensee, but instead violates the statute and is subject to enforcement under the state's police power. The state's right to act arises not from consent, but from its sovereign duty to protect public welfare, the very heart of the public trust doctrine. This concludes our video for today. We hope this information has been educational and of benefit to you. We thank you once again for tuning in, and until next time, peace and blessings to you all.